First of all, I would like to thank the organizers of the conference and the conveners of this panel for their invitation. Unlike most of you, I'm not an immigration and asylum law specialist, and this is actually the very reason of my presence today, since I was asked to analyze the issue of visas for asylum from a general EU law approach, contemplating first the impact of the Charter of Fundamental Rights and to the scope of application of EU law. So I will do so with a very brief analysis of the X and X case, raising three controversial, provocating comments likely to fuel our upcoming debates. And I must immediately mention that I find the judgment quite convincing from a legal point of view, despite, of course, the political, humanitarian, and ethical concerns it might raise. So, in the XX case, the referring national judge asked the Court of Justice to ascertain whether the Charter, or rather the visa code, interpreted in light of the Charter, implied an obligation for the Belgian government to grant a visa. So the applicants were invoking the Charter, seeking its potential added value in the case in support of their legal position in order to reach a positive outcome. As you all know, nevertheless, the court held that the situation fell outside the scope of the visa code and therefore outside the scope of EU law and therefore outside the scope of the Charter. The Charter thus had no added value and even no impact at all in the case due to the finding of its inapplicability. This will probably not soften the skepticism or the criticism of many of you regarding the judgment, but the finding of the court regarding the inapplicability of the Charter is not surprising at all to me from a general EU law perspective, and is, in my view, consistent with the whole body of case law regarding the scope, the applicability of the Charter. So, during the drafting of the Charter in 2000 and during the Convention on the Future of Europe in 2002-2003, there were broad concerns among some negotiators of the text that the Charter could be used by the Court of Justice as a tool for further integration. That the court could be tempted to hold the broad interpretation of EU law, of the scope of EU law, to broaden the scope just in order to have a say on more and more national situations and scrutinize them in light of the Charter. Article 51 of the Charter was therefore carefully drafted in order to reflect that the Charter cannot have any autonomous effect under EU law and that the member states are only bound by the Charter in situations where they implement EU law, which, as was later clarified by the case law, means when they act within the scope of EU law. These careful and influential negotiators who imposed the drafting of Article 51 were, in my view, very successful in the long run. Why? Because, as expected, the Charter is invoked against national authorities more and more often since its entry into force in 2009. But it did not entail a broad extension of the scope of EU law at all. Quite the contrary, the court took the opportunity brought by these hundreds of cases involving the Charter to refine its methodology as to the definition of the scope of EU law. So, robustifying its approach, let's say, the court set out new criteria to ascertain whether a particular situation fall outside or inside the scope of EU law. But above all, it engaged, and it also required national courts to do so, it engaged in a much more cautious and active scrutiny of the specifics of each situation at stake to ascertain whether a genuine link to the scope of EU law can be found, and especially where norms of secondary law are concerned. So this global trend can notably be seen clearly in different lights of case law of the Court of Justice regarding movement of persons in the broader sense, where fundamental rights play little role, if any, despite their invocation by the parties, because of the obvious willingness or readiness of the Court of Justice to refine or even, let's say, sharpen the scope of EU norms applicable to the movement of EU citizens, of EU economically active natural persons, and of third country nationals. This is thus my first comment. The inapplicability of EU law and of the Charter in the X and X case, based on a close examination by the court of the factual situation at stake, despite being disappointing or shocking to many, must be seen as an evidence or a confirmation of a more global and identified trend in the case law of the Court of Justice regarding the Charter. My second comment in close connection to that is that the court had very good legal and legitimate reasons to hold that the application in the X and X case fell outside the scope of application of the Visa Code. Even if disappointing, again, the reasoning of the courts denying the applications to be labeled as short-term visa application under the Visa Code is carefully substantiated by reference to the scope of the Visa Code, to the wording of its provisions, its general structure, the intended purpose of its authors, as well as the competence of the EU as set out in the treaties. The court also rightly points that another interpretation would be inconsistent with the global structure of visa norms and asylum norms under EU law, especially since the legislator has not exercised or not yet exercised its competence conferred by the treaties regarding the conditions governing the issue by member states of long-term visas to third country nationals on humanitarian grounds. So we sometimes, as academics or policymakers, tend to favor policy outcomes. And we also all have been legally trained to EU law with old stories of activism of the Court of Justice. But I think times may have changed in this regard, and we shall not forget that the mandates of the court do not allow it to disregard the law as it stands, even despite the regrettable outcomes to which its application might lead. So, judges have a legal mandate under the treaties, a different role in society and in legal communities than scholars, and a different operating system, let's say. So, therefore, I firmly believe that the reasoning of the court was the only possible one on legal grounds. The court cannot be blamed for stating in substance that there is no legal basis regarding visas for asylum at the current state of EU law, and that any change in this regard should come from the elected legislator rather than through a disruptive interpretation of the current norms. Third comment, at last, and maybe to see the glass half full rather than half empty, the choice of the court to hold that the situation in the X and X case fell outside the scope of EU law and the Visa Code might, from a certain perspective, be considered as a balanced approach or even a lesser evil. Why? Because by doing so, the court may be intended to avoid stating that the Visa Code was applicable, but that EU law bore no obligation for the member state to grant visa in the particular case. In the same vein, by doing so, the court held that such visas are not to be granted under EU law, but it refrained from any finding which could be detrimental to the recognition of such rights under national law or under other international legal orders. So to echo the title of our panel, visas for asylum are not to be granted under current EU law, but it remains to be ascertained whether they might be granted on other grounds. And I therefore left the floor to my fellow panelists. Thank you for your attention.